Supreme Court Judge nominee Justice Philip Bright Mensah is calling for a significant increase in the number of judges at the Supreme Court, arguing that 20 is most appropriate to effectively function because of the workload. Also, on the big stories today, MPP sets the stage to elect presidential candidate in January 2026 following a decision taken at the National Executive Committee. What does this new arrangement mean for the party going forward? We hear from our panel on these issues. Joining us, we have Dr. Richard Amwako-Ba. He is a political scientist. Dr. Kwabena Alpha-Kennedy is a political activist and a medical doctor. Lawyer Martin Pebu is a legal practitioner, and Dr. John Osai Kwapong is a CDD fellow. Thanks very much for joining us here. Let's start with the legal, system and bringing Martin Pebu. Martin, the Chief Justice, the Supreme Court judge nominee is proposing that the Supreme Court should have at least 20 judges. And if you listen to him, he makes an argument about the workload at the Supreme Court. And he says in the 2020-2023 season, if you look at a report by the Chief Justice, there were over 700 cases that could not be resolved because of the lack of judges. What do you think of this proposal, looking at where we are now, the legal system, and where we want to be?
Okay, yes, Kojo, the point is that, yes, that's one opinion. It's not new. There are some adherents of that opinion that we should cap it at 20. But where I come from is that we need to have a national debate first. Okay. So what Justice Mensah has stated, yes, it's his opinion. It deserves consideration. But the reason we must have a national debate first is that it's been accepted that it is the convention in Ghana, and often you hear the convention is the law, that we have 15 justices of the Supreme Court. 15, right? Yes, some say it's 14 plus the Chief Justice 15, right?
Yeah.
Good. Some too have given it an interpretation that is 16, but I think it's 15. The 14 plus Chief Justice, you get 15. And it's been accepted. This case went to the African peer review mechanism when President Kufuor was president. You know, at that time, for the Chachuchikata case, when it came to review, you know, Kufuor had to appoint additional justices, and then it was said that he was packed.
Okay.
Then we agreed that, look, conventional, that is our number, 15. So if we are going to move beyond that number, let's have a debate. Let's have a debate first. Let all the people weigh in, especially lay people. Let's see how in the debate we'll agree to deploy technology to help reduce the load, etc. It is not a debate that or a decision that should be left with only the president and the Supreme Court justices. No, it's become very clear that we are saying it must be a national debate where we'll discuss it thoroughly and where a lot of people will be given opportunity to weigh in with their opinions. Then when we are done, the number we settle on, we go with it. Because, Kojo Brace, the reason I'm saying this is that you remember a few months ago, the matter of, hello, can you hear me?
Yes, loud and clear.
Okay, good. A few months ago, you know, when Akufo-Addo was president, there was this, there were the additional nominations. Let me call them, the letter from the Chief Justice, asking,
the presidents to make nominations to the Supreme Court.
If you wrong, we had that national debate on our own, how people were very upset about what President Akufo-Addo was doing, etc. So at the end of it, it became clear that we don't agree that the president and the Chief Justice alone should meet and decide the number. No, we are debating this case. Didn't start today. you'll find Professor H. Kwesi Prempeh brought out research that even the time of Adam Smith, the famous economist, he also had something to say about the justice system. And Adam Smith said, look, matters of appointing judges, etc., citizens should be allowed to also weigh in, to also express their opinion. So, Kojo, the upshot of what I'm saying is that because from President Kufuor's time, when we presented the African peer review this report, which our peers looked at and criticized Ghana severely for not sticking with the convention and thereby increasing the number beyond that, look, our convention is 15. So if you want to break the 15, involve the ordinary people as well. It's a democracy. It's a democracy. It's not an oligarchy. It's not a government by a few wise people. No. Let the ordinary people. I'm not saying that I'm necessarily tied to any number. I'm just advocating that let's open the debate. Then at the end of it, the collective wisdom. Remember too that we say that democracy is wisdom of the crowd. Democracy is wisdom of the crowd. So open it. Even if you like 20, go to the debate. Maybe many people agree with the 20. And then the rest of us will go along with it. What we are just saying is not on, is for an oligarchy, a few people to sit down and decide it. That one, no, it will bring us problems. So what I said when this matter came up last year is the same thing I'm saying today. Of course, there's not time to go over all the arguments. There isn't time. So, but if you read, you see that last year, when the Chief Justice Tokonu's letter came up, we had a robust debate, and we said no, we didn't agree. She shouldn't have done that. She shouldn't have sent that letter to Akufo-Addo. It cannot be a conversation between the Chief Justice and Akufo-Addo alone. It must be a national debate, etc.
All right. Mr. Kwebu, hold for me. Let's listen to exactly what Justice Philip Mensah Bright said, and then we'll come back and continue the conversation.
Minimum number that I will recommend for appointment to the Supreme Court, given the nature of the work they do, they are related with so many cases. Therefore, I think I would suggest 20 as judges that should go to the Supreme Court, because as a matter of rule of procedure, and it is also even backed by the Constitution, when the Supreme Court sits in an ordinary case, the panel is 5. The President will sit together with 4 other Supreme Court justices. If there is the chance to have the matter reviewed, 2 more justices will be added to it. So even in ordinary cases, you will see that in each case there are 5 judges who handle the case. So if you say that judges mustn't be sent to the Supreme Court, then it means that you are giving the court more and more, they will be settled with more and more cases, and they cannot have. So at any given time, when the panel or the judges in the Supreme Court are about 20, then we are saying that we have about 4 sets of panel of judges to handle those cases. So, Mr. Chairman, I will say, in my humble opinion, given the cases that are in the Supreme Court, I will recommend that 20 judges will be appropriate.
So that's what the Supreme Court's nominee has said. And I want to go to Dr. Kobinatha Kennedy at this point now. Doc, thank you for joining the conversation. This seems like a suggestion that he's making. And so the question I'm asking, is 15 judges inadequate for the volume of work and the complexity of cases at the Supreme Court to handle? And if not, will a larger number increase judicial dependence, or will it rather create room for greater political appointments and influence, like we've, seemingly seeing these days?
Good morning to you and to your viewers. I have heard the judge's recommendation, but if you listen to him carefully, he didn't actually say 20 would be enough. He said at least 20.
Yes.
And when you look at the date that he was quoting, he talked about them doing 344 cases out of 939, and subsequent years, the cases piling up. It seems like they are heading for 30 or 35 eventually. I think we need to have a national debate about our judiciary and its inadequacies. The judge raises a point about needing more judges to do the Supreme Court's work. It's reasonable. How much would that cost us? For example, are there other ways that will make our courts more effective? For example, the use of law clerks, which is done all the way around the world. More efficient use of panels, even while they are complaining about not getting work done. The Chief Justice arbitrarily interferes with panels. Sometimes cases that are almost finished are dismissed. So when you take all these things into account and you take into account the fact that other countries with larger populations are doing with less in terms of number of judges and getting top quality, I doubt the provenance of what he's saying. Nigeria has only 21, Kenya has 7, India, which has the largest, has 34, America has 9, Brazil has 11, and most of them still get justice done. I think that the reason why there should be a general debate about our judiciary and justice system is that for most Ghanaians, the nearest they will come to the law is the policeman on the street. So, for example, how well are the police trained? How well are lay magistrates trained? How quickly do cases move through the system? And in spite of piling on the cost, we are not that much better than most other countries. In Africa, we don't rank that high. We are beaten by the likes of Rwanda and Kenya and South Africa. So I think there needs to be a full-scale discussion about judicial reform in the context of cost, because of course we need more doctors.
Yeah.
Nurses will be on strike because of insufficient money. How much would this cost? And as for his suggestion about learning the Chinese language, I bet you that they are hearing cases from Ghanaians of all tribes whose languages most of the judges don't speak. And nobody has suggested that they learn to speak all those Ghanaian languages.
Okay. Doug, let's stay on the issue of costs now, because I want to find out what's the trade-off between increasing the numbers and investing in court automation and judicial reforms. Because like you mentioned, there are other countries who are doing okay with less numbers. So at what point do we start talking about automation in our judicial system?
I say now. It is never too soon to do that. And I think that there are a lot of other things. The judiciary can be more cost effective, things like judicial holidays, cases that language for a long time, because if it takes you almost a year to handle an election petition, and the United States can handle an election petition at the Supreme Court in 2 weeks, maybe that is part of why your system is too expensive. And these things are onerous and burdensome on people. We should look at, for example, people who are sent into remand. Nobody says anything about them for years. So I welcome the judges' ideas, but we should take advantage of this to have a full-scale discussion about our judicial system, impudence on the part of judges, their commitment to national principles, and their frugality. All those things should be on the table.
Could you?
Well, let me bring in Dr. Osei upon here. Doc, so you followed our democracy for quite some time now. Where we are now, Dr. Arthur Kennedy is making the argument that if you compare democracy to other areas, even in, India, which has the most populous, one of the most populous countries, they are only doing with 31 Supreme Court judges. So, I mean, is there a justification for us to increase our judges on the Supreme Court? or it is rather the system that we must look at fixing?
Good morning. Thank you very much. So I think it's a two-dimensional issue that we can take a look at. I can understand the administrative burden that the nominee is trying to draw our attention to, which is the volume of cases, the number that went unheard in the 2023-2024 year, and in his thinking that perhaps if you have a few more justices on the Supreme Court, the number 20 is adequate to handle the volume of cases that comes before the court. Yeah. What I have asked myself is, well, why 20? Someone could also make the argument that, well, given the volume of the cases before the court, why not 25? Why not 30?
The 20, he gives it the minimum at least.
Right. So what is that magic number that would allow the court to be able to efficiently and adequately handle the volume of cases that comes before the court? I'm not sure what that number is, but as both Dr. Arthur Kennedy said and Lawyer Martin Pegu said, it requires a lot more conversation, with all of the stakeholders to try and figure out exactly what the issue is. Because perhaps there are also other systemic issues that if we made tweaks to the system, that 15 or even less will be adequate for the courts to be able to handle the volume of cases that come before it.
I mean, but does this call or this suggestion reveal or reflect a crisis of capacity, or he's talking about a deeper issue with how our Supreme Court is actually organized? What is he actually trying to address with this suggestion?
I think based on what I heard him say, I think he's trying to draw attention more to a capacity issue. Okay. And by a capacity issue is essentially whether we have the adequate number of justices on the court to deal or handle the volume of cases that comes before the court. And he's looking at all the number of unheard cases, and he's thinking, well, maybe if we had a few more hands, we should be able to deal with all of the cases. So I think he's looking at it more from a capacity issue in terms of numbers to handle the volume of cases before the courts.
But Lawyer Martin Pegu, let's bring you in again. Now, if you look at the numbers, the Supreme Court was able to do just 334 cases out of 939 pending cases in 2022, 2023. In 2021, 2022, they did they left a backlog of 414 cases. I hear Dr. Arthur Kennedy talk about automation. You're a lawyer and you know what our system is like. What should be the focus of this automation just to help us clear this backlog to then say, well, it's probably not a matter of numbers, but an efficient system that can help us, deal with cases as they come?
Okay, yeah, so, Kojo, it's not just about automation. There is a bigger problem than automation. Okay. You see, that one of the main problems that the cases that we don't have, a higher number of cases being dealt with is what we call the process serving system. So when a case goes to the Supreme Court, there are some officers who have to go hand over whatever has been filed to the lawyers and the parties. So let's say Kojo Brace, you've sued Suti Abochi, right? Now, in terms of the officer who will go and present the court document to Suti Abochi, there are not enough of them. So a lot of the time, you would dress up, go to court, and the officer will say, oh, I've not been able to contact Suti Abochi. Come and take me to Suti Abochi's house, etc. And you know, Ghana, where we have a huge problem with the address system, there you see that it's a big challenge, right? So the problems are many, but this particular one, in terms of delivering the documents, it's really, really horrible. It's horrible. I mean, I don't even know what was the strongest, if there's any stronger word than horrible. It's as if we don't even know what we are doing. It's terrible. So to go find Sweetie Abuchi, it can be 1 year. You see Sweetie Abuchi walking around here, but to go find her and serve her, it's a challenge. It's such a huge one. So we will need to do reforms where we will employ a lot more process servers. And if employing them, I'm not in favor. I'm in favor of the system where we will deregulate and allow more players to come into the system. Ghana Post will participate, other private companies will participate, so that at every point there are a lot of what we call the process servers. They are simple names. You hear bailiffs.
Yeah.
Because the current system, with that shortage, no, you have to tip the bailiff, and if it's still...
Mr. Kwebu, it sounds like you're saying the system is overly centralized. So should we be looking at creating specialized appellate courts rather to help ease the pressure instead of increasing the number of judges at the Supreme Court?
Well, we can look at that too, but to make the point again, what I'm saying is that the administrative support before the case is heard is quite a challenge. And one of those administrative support systems, I'm talking about the bailiffs, getting bailiffs to serve, is terrible. It doesn't work well, right? So you dress up and go, and the documents have not been served on the other lawyer, so he's not coming. Look, you can have a case hang on for like 2 years or more because they are still having challenges with serving. So what you're saying in terms of having more specialized courts, yes, more may help, but I'm looking at how we can make the system here more efficient. Just as the doctor mentioned the automation. Yes, automation is also great, but I was just adding on that the bailiffs, we don't have enough bailiffs. We shouldn't continue to use 4 or 5 bailiffs for the whole Supreme Court, right? We should deregulate so that more actors will come in, so that the moment you file, when there's competition, so right now there isn't competition. No, it's been given to a few people and it's a monopoly and it's terribly bad. It affects the work of the Supreme Court. And so I'm saying that let's look at it as one of the key areas that we can bring in more people to increase efficiency. Okay. Whilst we also tackle the automation, which is also quite a serious problem. Okay. And many other issues, right? In terms of timelines on when the cases will be heard. Right now, there are no timelines, so you can have one case pending for 3 years, another case can come today, and in 6 months, that one will be dealt with, maybe because it is politically sensitive, etc. So we will need more rules. The Supreme Court will certainly need more rules to streamline the work.
Interesting. So for you, the 414 backlog in 2021, 2022 is not because we don't have judges, but because we don't have a number of bailiffs who can help in the, getting these cases to the people that must be served.
Yes. And then if we are opening the gate for us to talk about all the other reforms needed, then also another one is the, the assistants to the judges. There's a name for them. So each judge is supposed to have lawyers to assist. If you compare with the U.S. Supreme Court, right, one justice, some of them have 4 top lawyers to assist them do their work. 4 top lawyers. So it's not it's not a joke. In Ghana, you go, we've had that system, but it hasn't worked well. From the 80s, well, maybe if it was there in the 70s and 60s, I don't know. But I know that in the 80s, it existed, where you have one Supreme Court judge having one assistant, a lawyer to assist. It's not sufficient. Look at the US. You have 4 lawyers, crack lawyers to help the judge do their work. Ghana, we do it a few years, then funding dries up, then we stop. Currently, for some years now, that system is in place. But the last time I knew, they were having only one lawyer to a judge. One lawyer to a judge? No. Let's copy. Let's go and understudy. In the US, those assistants to the judges, it's a whole service by itself. You will get promoted, etc. So conditions are well laid out. Ghana, that system is not well, what do you call it? It's not lucrative.
Okay.
It's not lucrative enough, so crack lawyers won't be looking in that direction. No. But in the US, let me show you an example. You see the current US Supreme Court, the Chief Justice, Roberts. Roberts was a clerk to the one who died, Chief Justice Rehnquist. So years ago, decades ago, when Roberts left school, he came and clerked Rehnquist. And when Rehnquist died, was it 2005 or 6? I would have forgotten. Yeah, 5 or 6. Then they brought back Roberts to come and take over as Chief Justice. You look at Gorsuch. Gorsuch was a clerk to Kennedy. Kennedy is the one that had problems with Trump. Trump said he should resign, he should go. Yeah, Kennedy went. Then Gorsuch came.
Right.
There are other examples. A lot of the Supreme Court justices you find in the US, they were once clerks to previous Supreme Court justices. So they see that their system has worked for decades. Ours, small salary, you don't get crack lawyers going there. No. So we need to sit down and have a proper conversation that we want to streamline it, we want to bring in greater reforms, then the work can be more efficient. So it's not just about increasing numbers. Otherwise, 2 years from now, we'll come and say, oh, from 20, let's go to 30, etc.
Martin Kpebu, thank you so much for joining us. I want to ask Dr. Kennedy, what would this debate look like? You said we should have a national debate of a sort on our judiciary and how we want to move forward. How would it look like? Like the national dialogues we've been seeing? In what form or shape should it take?
It should take the shape of, for example, the Ghana Bar Association going to a conference and having a session on it on which people who are knowledgeable, including judges and other lay people, come and talk. I think that lawyer people makes a good case. But actually, the US case is not because they are paid well. Being a law clerk is a very important step to going on to a prestigious legal career, whether it is in private practice, whether it is in academia and others. So when people finish law school, the top students are looking to apply to go and serve as clerks either at the Supreme Court or appellate courts. But another thing that we should look at when we do have the debate, which should involve obviously the Ghana Bar Association, the Judicial Service, the law schools and their professors, as well as political players, should have these things, including things like certiorari. It might be, for example, that the Supreme Court gets too many cases. In the United States, they have something called certiorari, which means that every year the Supreme Court looks at all the applications that are made to it for cases, and it picks maybe around 70, 75 to hear, which they think are significant. I think maybe a lot of mundane cases are going to the Supreme Court that other courts can handle. And as to the question about numbers, you know that, Mr. Pebu says very eloquently, there are cases that have languished for about a year, but we saw last year during the petition to remove MPs that some people filed a case in the by afternoon, a panel was sitting, which means obviously that the case is not just a queue. In that queue, there are some people who are more equal than others, and that maybe the judges are too politicized. So all those things should be part of the debate.
I mean, the U.S., when the Supreme Court selects the number of cases they think they can adjudicate, what happens to the remaining?
They go away, and maybe next year you might refile them. But a lot of them, if the Supreme Court doesn't take the case, it means that the appellate court decision will stand. Okay. You know, if even they take it and the Supreme Court splits, recently there was a case where one judge recused herself. The remaining 8 split 4-4. So the appellate court's ruling became the law. But that is a very important process of controlling the number of cases that go to the Supreme Court. And we call that granting cert or certiorari. And these appeals to the Supreme Court can come from everybody. Indeed, there's been a case where a lay prisoner wrote an appeal to the Supreme Court, and while he was in the prison, the Supreme Court took the case. So they look at what they think are foundational. They go to constitutional issues, so they are law issues. For example, if you go to places like California, where the courts are more liberal, they will rule one way. If you go to Virginia, they will rule another way. So if you have a similar case in which different appellate courts have ruled different ways, it's one of those that they should take.
Okay.
If you have one foundational, like affirmative action, Brown versus Board of Education, they will take something like that. And then recently, in the last 2 years, for example, something like Chevron's case, in which the administrative case came in. Then you have things like the COVID vaccine. So even though they pick case at the beginning of the year, when during the year things of moment or significant impact comes, like since Trump came, they've been taking a lot of unusual cases involving immigration and citizenship and the right of the federal government, for example, to federalize the National Guard, stuff like that. So all those factors come in.
Okay. Doc, please hold for us. Let me engage Dr. John Osai-Kwapong on this matter finally, and then we'll move on to the NPP's election date. So, Dr. Osai-Kwapong, we know what the Constitution says about the judges at the Supreme Court, although there's a Constitution review underway. Are these proposed changes, these suggestions, within legal bounds?
Yeah, I mean, if we really want to make the kinds of changes that the nominee is proposing, it may involve, taking some of these suggestions to the Constitution Review Committee to deal with it. I mean, if there are other ways that it can also be dealt with without resorting to, tweaking the Constitution within legal bounds, I think that should be fine as well. But I know the debate has also, part of this debate is not also just about should we increase the number, but there's also been conversations about should we even cap the number, and perhaps this is an opportune time for us to sustain this conversation and settle on whether we want to cap it, and if we want to cap it at what number, or if we want to still keep it at a certain minimum, what is that required minimum that is needed.